Good afternoon, everyone. Thank you for joining us today for our session on employees with a mental illness. And we're going to be talking about obligations of employers in managing that. Today I'm joined by a different team today. Before I go into that, I'll talk about our sponsors today, Workplace Assured. For any businesses after the complete workplace relations solution, you can visit workplaceassured.com.au and find out more about that. There's also a 2-minute risk profiler there for anyone who's interested. Today I'm joined by Kate Thompson and Lewis Izzo, who is replacing at very short notice Alana Patterson, so thank you for that, Lewis.
It's quite alright.
For anyone who hasn't joined us before, you can interact via the chat box in the left hand of your screen there and answer any questions. They'll pop up throughout the presentation, and the guys will try and action those as we go, and we'll also take questions at the end as well if we have time. I'll now hand over to Kate just to get us started and talk to us about what they're going to cover today. Thanks, Kate.
Thanks, John. So today we have a brief overall theme of mental health in the workplace, managing your obligations as an employer, with a few specific subtopics under that. So firstly, we'll discuss mental health in the workplace, the impact it can have on your workplace. Then we move to managing mental health in the workplace with a really specific focus on making reasonable adjustments for a worker with a mental illness. And as we move through that discussion, you'll see why we have actually spent quite a bit of time on that area. So in performance management, we have discussed how to performance manage a worker with a mental illness, with some discussion of the risks associated with that. And then Lewis will talk specifically about legal risks and then move to some relevant cases as well. So we've got some statistics here to start with, just to demonstrate how prevalent mental health in the workplace is as an issue facing employers. So 45% of Australians aged between 16 and 85 will experience a mental illness at some point in their life, which is 1 in 5 Australian adults in any given year. It's actually the third biggest health problem in Australia after heart disease and cancer, and depression is currently the leading cause of non-fatal disability in Australia. Specifically, 3.2 days per year per worker are lost each year due to workplace stress, and it's approximately 25% of workers report taking time off each year for stress-related reasons. Australian businesses lose over $6.5 billion each year by failing to provide early intervention and treatment for employees with mental health conditions. So you'll see, based on those statistics, why it is an important issue for employers to discuss, to manage, and to try and reduce the cost impact on the business. So here we have some common conditions. We generally separate them into 3 lots of conditions, being mood disorders such as depression and bipolar disorder, the second being anxiety disorders, and the third being psychotic disorders such as schizophrenia and some forms of bipolar disorder.
And what we see generally in the workplace, it's probably more the top 2 that we see in terms of conditions that employees suffer from, so either the mood disorder or the anxiety disorders. Psychotic disorders we come across less often. They can be quite serious when we do come across them, but it's generally adjustment disorders and things like that, depression, that take up most of the type of conditions that we come across when advising employers from time to time.
So here we have an overall look at how to manage mental health in the workplace, your obligations as an employer, and you'll see that these have a lot of commonalities with managing other issues within the workplace, such as bullying and harassment. The first one we look to is work health and safety. So the relevant work health and safety legislation in each state does require an employer to provide a healthy and safe working environment which doesn't cause illness or injury or aggravate an existing condition suffered by an employee. Secondly, disability discrimination legislation requires that your workplace or any member of it does not discriminate against or harass an employee with a mental illness, and there's state-based legislation which covers this area as well as the Federal Act as well. In this discrimination legislation area, we also find the requirement to make reasonable adjustments for employees who have a mental illness. The third area that we go to, which is another federal act, is the Fair Work Act, which requires that employers do not take adverse action against an employee because they have mental illness. And secondary to that as well is the requirement not to take adverse action against an employee because they have absences from work, short-term absences from work. The third, or the fourth rather, aspect there is the privacy legislation, which as an employer, having access to private information about your employees prevents you from disclosing that information about their mental illness or any other details about their health without their consent.
So when we then look at when is it necessary to take action, take action is kind of a little bit of a strong word, but what we're really talking about here is when does a mental illness issue in the workplace reach a level that the employer needs to start intervening one way or another. The areas that we most often get called upon to advise on relate to, firstly, as you'll see there, when there's long-term absences. So often employees can go off for extended periods of time. Employers start to say, well, hang on, we need to work out how we can appropriately resource our operations in order to ensure things keep going on. And so at that point, you might think, well, we need to start to get a grip on the reason for this absence, when the employee is going to return, how long are things going to take. So that's probably the most common time when we get involved. Frequent short-term absences can also provide a basis. So you might have an employee who is absent maybe one day every week, one day every kind of 10 days or so, and it starts to have an impact on the workplace, and at that point you might see employers starting to need to grapple a bit more with the absenteeism issues. Poor work performance is an interesting one. It may well be that mental illness is affecting someone's work performance. That's something that an employer is going to need to be very sensitive to, because you can't be dealing with a performance issue with an employee who does have mental health issue, concerns in exactly the same way as if they didn't have mental health concerns. We're going to work through matters that Kate's already discussed, like reasonable adjustments. There's indirect discrimination concerns that apply. So when it comes to poor work performance, you just need to be conscious. Yes, we can step in and take steps to try and improve the performance, but you do really need to deal with performance issues in this space quite carefully. Same would apply really for poor timekeeping, and even behavioural concerns. The way you might respond to behavioural concerns for non-mentally ill employees is going to be different to the way you respond for mentally ill employees. And lastly, but certainly not least, if you consider there is a risk to the safety of any employee or any person at your workplace, at that point you really do need to step in quite promptly. So they're the general circumstances in which we see employers get involved. If you are aware of a concern that's arising, then it's very important that you take action at an early stage so that things don't start to unravel later on. And we're going to talk about, over the next few slides, the types of steps that you can take to put you in a good position to manage these types of issues.
So we have a bit of a timeline here about what first steps we should be looking at and how to start this process. The first thing we need to be looking at, and this is an issue that we need to look at when dealing with any type of illness or injury suffered by an employee, is what are the inherent requirements of the job? Quite often people get distracted by things which are not inherent requirements of a role, so things which are not key to the performance of the job, and that's a really important question to look at first off. And the second question to look at is, are there any work health and safety risks to the employee if they are required to perform the inherent requirements of the job? And when we talk about work health and safety risks, we're looking at things that their mental illness or their condition that they suffer may be contributing to in preventing or making it more difficult for them to perform those inherent requirements.
And one thing I'd say about that is it goes without saying that for all employees, one of the inherent requirements is the need to be able to perform the job safely. And that's something that employers need to be conscious of. So if you are looking at issues where an ability to perform a job safely is being compromised, that's something that's automatically going to go to the core inherent requirements. One of the other things to bear in mind, and I think Kate touched on this, is not all requirements of a job are inherent. You really need to focus on those aspects that really lie at the heart of the position. And that can be a difficult exercise. It's a judgment exercise. You need to look at someone's position description and those kind of things, but it's just something that you have to do on a case-by-case basis.
Thanks, Lewis. That's very true. And then, I suppose that then leads into our next question, which is assessing the employee's skills and abilities against the inherent requirements of the job. So what is the employee actually able to do? Are they still able to perform the role that they were originally employed to perform? And have you got some medical evidence which the employee has either provided you or you've obtained with the employee's permission to demonstrate whether or not they are now able or no longer able, as the case may be, to perform those inherent requirements? Then we move into the trickier area of things, which I suppose is where we start to think about, if the answer is no, the employee isn't really able to perform the inherent requirements of the job any longer, whether or not there are any reasonable adjustments which can be made to the role to allow the employee to perform the role. Now, this is actually a legal requirement that an employer is required to look at. You can't just say, unfortunately, you're no longer able to perform the inherent requirements of your job because of your illness or injury, be it a physical illness or a mental illness. We actually have to ask those questions, look at those options. And the first thing we suggest is being open to suggestions and actually listening to your employee about what they've got to say. Does the employee have some suggestions which might assist them in being able to perform the inherent requirements of the job? And what does your workplace lend itself to? Particularly, what does the employee's job lend it to? Some roles will obviously have much more flexibility than others. Depending on your workplace, depending on the role performed by the employee, will depend on what's a reasonable adjustment. The other thing that you might wish to look at is researching other areas or other industries or other individuals who suffer a similar mental illness to that suffered by your employee, and whether or not those other options or those other examples are able to provide you with some guidance about what might be a reasonable adjustment. But I'll talk some more about some reasonable adjustments in a minute to give us a better idea about some examples so that we better understand what we're talking about. The next question, I suppose, and we're getting a little bit ahead of ourselves, but I'll just foreshadow this now because it's relevant to our discussion of reasonable adjustments, is having that reassessment about whether or not the employee has the capacity on an ongoing basis to perform the core requirements of the role once you've actually put those adjustments in place. So here we've got a few general examples of reasonable adjustments. Now, reasonable adjustments are something we talk about when we talk about employees with a physical injury or a physical illness as well as a mental illness. So generally we want to be thinking about changing the job or the tasks, providing a flexible working arrangement, making changes to the workplace, or purchasing modifying equipment. So those are the four main areas that we talk about when we're thinking about what's a reasonable adjustment. Here is a much more in-depth list of examples dealing with some of the challenges or the issues that workers with a mental illness might be facing. So along the top there we've got the need for flexible working options, so some examples there underneath about what those might be. You might think about variable start or finishing times or working from home. Then we move to making adjustments for an employee who has strategies for difficulties with memory, which is a symptom of a range of different mental illnesses or the medications used to manage those conditions. Similarly with concentration, there are that can be a symptom of the illness itself or a side effect of the medications that someone's taking. So, for example, taking simple steps like giving written instructions to an employee or providing frequent short breaks might be the things that that employee needs to be able to perform the job. So if an employee is having difficulties within the organisation, with organisation, so with task completion, we might think about things like giving greater structure to deadlines or providing reminders by email about deadlines. Simple things that an employer can put in place to assist an employee to ensure that they're not only remembering all of their obligations, but also ensuring that they're completed in a timely fashion. Then we move, I suppose, to some of the more difficult areas and some of the more stressful areas for an employer to deal with. So, for example, an employee who might have difficulty with social interaction. Someone in this situation might not want to be as involved with the workplace as they once were. So amendment or accommodation can be made by, for example, not requiring attendance at social activities or allowing the employee to work from home.
And obviously, though, in relation to that, again, you need to be looking at these adjustments in light of the inherent requirements, because whilst these are valid adjustments you might make, at the end of the day, if part of someone's role requires them to be in constant contact with other employees in the workplace, something like working from home might not be workable for them. Take a manager, for example. If you're a manager of staff within a business unit, it might not be appropriate to have that manager sitting at home the entire day when the staff are all in the workplace. So it needs to be considered within the actual job specifics of each person.
That's right. Of course, the
it might
reasonable
work for some.
adjustments are what's reasonable for your business. It doesn't mean that you have to make every possible adjustment if it's not possible. As Lewis was saying, some roles don't lend themselves to particular amendments. And there might be other considerations such as cost, which have bearing on the decision-making process. But I think it's important for us to have a look at and talk about the wide variation of things that can be made and the wide variation that might be regarded as reasonable adjustments, because people get very fixed and stuck on things that they think might be appropriate. As I said earlier, the thing we really need to be looking at is and offering the opportunities for the employee to provide some feedback about what it is that might make their condition or their ability to perform the job more successful and easier for them. We've also then got a couple more examples on that slide. So strategies to address physical symptoms and strategies to address absences from work. And then finally, strategies to address difficulties with emotions. And anyone who has dealt with a highly conflicted workplace will know that none of these things are particularly easy to deal with, particularly when we have the spectre of other risks at play as well, such as discrimination. But indeed, they are necessary and they are important for an employer to address and have a think about to avoid the situation becoming exacerbated and the employee ultimately ending up in a situation where they cannot continue in their role, whether that's at their initiative or at your initiative. Ultimately, however, you may have to resort to performance management. Even if an employee does have a mental illness, you are entitled as an employer to apply your standard performance management system where you have a legitimate concern about how they're performing. So the first step is to think about what your concerns are about the employee. They might be behavioural or they might be performance, in that perhaps the employee isn't meeting the objectively measurable targets that you set for all of your employees. The next thing to have a think about is the personal circumstances of the employee, which might be contributing to their inability to perform to your expectations or their behaviour. Then relevant is whether the employee's mental illness is affecting their performance. Now, the difficulty might be sometimes if you weren't actually aware that the employee was suffering from a mental illness before you started the performance management process, and this is information which has become known to you during the process. I'll deal with that in a minute, that situation which arises, but then I think regardless of whether this is new information or not, we really need to be thinking about how serious are the performance concerns. I suppose the next question from that is, not only how serious are the concerns, but what do the concerns actually relate to? Are they behavioural concerns which are incidental to the inherent requirements of the job and aren't causing any risks to the health and safety of your other employees? Or do the concerns about the performance of the employee relate to an inherent requirement of the job? The next step, as with any performance management process, is having that discussion with the employee and allowing the opportunity for them to have some input. As I said earlier, if you're already aware that your employee has a mental illness or that this is something which becomes apparent during the performance management process, you may have to think about whether you implement your standard performance management process or whether you approach the process in a different way, or whether you indeed give the employee a bit of time to see if their illness improves and therefore their performance improves as well. Alternatively, instead of implementing your standard performance management process, you might wish to skip directly to the stage of seeing if there are any reasonable adjustments which can be made to the role to enable the employee to perform in accordance with your expectations. And that's likewise with behavioural conduct as well as measurable outcomes and efficiencies.
One of the things that's important to bear in mind here is there are also, and we'll come to this when we get to termination, but there are limits on what you, as an employer, can feasibly determine an employee can or can't do. So at the end of the day, if you've got an employee who says they've got particular constraints on their ability to do work, it might be difficult for you to form a view as to whether that's the case or not, whether that's linked to their mental illness or not, what adjustments you can make without actually getting the right medical advice to influence that decision. So that's the point at which you might need to be sending this person off to get independently assessed. You might be asking them to see their treating doctor. There's all those kinds of issues that arise because you won't be able to work all of these things out on your own necessarily. And I've just noted while I'm speaking that one of the questions that's come up is whether an employee has to disclose that they have a mental illness. That's actually quite a curly question, really, because it's going to depend on the circumstances. Ordinarily, the reason that we end up talking about mental illness is because they have disclosed their mental illness. So often there's a performance concern, there's a behavioural concern, or that they're off unwell, and because of that, they've informed the employer that they're suffering from a mental illness and that's what's affecting the work. And then the employer goes down the line of making inquiries. But that's not always the case. It might be that an employee is absent from work and not telling you why. And so to respond to the question, well, do they have to tell me why? Well, the answer is, on occasion, the answer is going to be yes, and it's for this reason. An employer has a right to issue lawful and reasonable directions to put in place arrangements to properly resource its operations. If you have an employee who's absent, not telling you why, you can issue a direction to go and get an independent medical assessment, to tell the employee that they must provide their consent so that a medical report can be furnished to give the employer an understanding of exactly what's going on and what the prognosis is for the employee to return. And often when it comes to safety as well, if we're talking about a safety concern, then that becomes even more important to understand exactly what the mental health issues are. And so at that point, the employer can direct the employee to provide medical information regarding the illness. Now, the only other thing I'll say on this is that, do they have to consent? Well, no, you can never force someone to give their consent. Forcing someone to do something is the opposite of getting consent. But if they refuse to provide their consent, that can then lead down a disciplinary path. So that's essentially in response to that question. And I think that answers the next one as well about can you request a medical certificate if they disclose a mental illness. That's broadly in the same vein. And yes, if the situation is that you're concerned that they might not be fit for work or something like that, then you can request medical clearance. So I'll hand back over to Kate. Having interrupted her there.
That's no worries. I think those are really relevant questions as well. And I suppose it does then tie into my next point, which is that notwithstanding the fact that an employee might have a mental illness, just as an employee with a physical illness or an injury might be having difficulties, we still need to be clear with the employee that their behaviour or their performance isn't meeting the standards of the workplace, and why that's the case, but that you are indeed willing to work with the employee on improving those things rather than proceeding with a formal performance management process, which, depending on your policy or the way you implement those processes in your workplace, might ultimately result in disciplinary action. We then encounter the difficult situation, which is if you don't have any reasonable adjustments which can be made to the role. So going back to Lewis's example earlier, which is the manager who needs to be on deck all day, every day to be performing the role. Difficult to make some reasonable adjustments there, such as working from home or limiting the communication that person has with their employees. So it is possible and it is feasible that there will be no reasonable adjustments. And then as well, you may make some reasonable adjustments that don't actually work, that don't improve the employee's performance, whether it's because of an unwillingness of the employee to participate in the process or just an inability because of the nature of their illness. So the employee should be told in that circumstance that a performance management process and a formal performance management process will be the likely outcome in the future. So where there is no improvement, we start to engage in a performance management process like you would with any employee whose performance is not up to scratch. Outlining your concerns, preferably in writing, providing clear goals or expectations for the employee's performance, so putting measurable things in place there as well. So if it's a behavioural thing, we might be putting clear guidelines in about what's acceptable behaviour and what the employee can do to improve. Conversely as well, if the thing that needs to improve is the employee's performance, that might be measurable by KPIs or sales targets, but making sure we're very clear with the employee what it is that we're actually seeking from them and how they need to improve. The third thing there is putting a timeline in for improvement, so not letting the process go on forever, but then also at the same time not requiring the employee to perform miracles in a very short period of time, actually putting a reasonable timeline in place to say, okay, here's what we're going to assist you to work with and on, and this is the time frame that we'd like you to achieve it in. Ultimately, and as we're all aware, unfortunately sometimes these processes don't work despite your best efforts, and in those circumstances, disciplinary action might be the only result, but the important thing to emphasise throughout this process is it's not because the employee has a mental illness that you're implementing this process, it's because they're unable to live up to your expectations in terms of their performance or their behaviour, and it's for that reason and that reason only that you're trying to work with them on those things.
Now I'm going to talk about contemplating termination. Before I do that, I actually thought Kate mentioned that at the end we're going to talk about some of the cases, but the one that's allocated to me, I might actually steal that and bring it in here just to build on some of the things that Kate was saying. Because when we talk about these performance management issues or behavioural issues, that before we even get to termination, when you're dealing with concerns, one of the recent cases that caused an employer a bit of headaches, kind of instructive of the issues that you might come across. So the case, and you'll see it later on the slides, is Ronaldo, Salazar, and John Holland. And what happened in this case was that essentially there was an employee that was asked, in fact directed, to change work crews from one particular aircraft maintenance crew to another aircraft maintenance crew in order to meet the requirements that John Holland Aviation Services had in relation to their resourcing. They effectively needed a certain number of licensed aircraft maintenance engineers on one shift and the same on another. And the employee started reacting quite adversely to this direction, started to behave in quite an odd and unreasonable manner, and in fact sent an email to management alleging that certain managers were incompetent and were trying to kill him and his family, that he was being denied his legal rights, suggested that there may be a repeat of certain airline crashes that had recently occurred, so started to talk about quite salacious and dramatic things in defence of his position, threatened to take his complaints to Today Tonight or to 60 Minutes or the Prime Minister, and started to really go off with this kind of wide range of quite broad, sweeping, dramatic allegations, all because he was being shifted across a shift. And the employer, John Holland, came in and actually said, well, you're out of line here. This behaviour that you're engaging in is actually misconduct, because the way that you're behaving is completely out of line with what the matters we're discussing are. The exact words are that your statements are incorrect, without any valid justification, extremely serious. They appear to be designed to cause maximum damage to the business and to be threats made to achieve a particular industrial objective of yours. Now all those things were quite right in one sense from John Holland. It does appear that the employee was being essentially making these grand and exaggerated statements to pursue and very serious statements to pursue what was his own personal industrial goals about not wanting to move a shift. The employer ultimately moved to terminate based on this misconduct and some other matters, and it was considered an unfair dismissal matter, and Commissioner Ryan actually determined that the employer had failed to take into account the medical psychological condition that existed at the time. The employee had been providing medical certificates. They were relatively unspecific in nature and didn't really indicate much about the condition, but there was a reference to a psychologist being needed. There was a reference to acute stress reactions, and in those circumstances where the employer was aware of there was medical evidence available and was aware that there was some kind of psychological condition, the Commissioner found, well, you couldn't just assume that this was all misconduct. You had to actually consider what the employee was suffering from and whether that exacerbated or whether that explained the behaviour, and ultimately found that there wasn't a valid ground for misconduct and that the dismissal was unfair. Now, this as it turns out, the case was actually appealed on the basis that in the actual hearing there was a failure to afford the employer procedural fairness, and the matter ultimately got settled on that basis. But the point remains that when you're dealing with these performance issues or behavioural issues, you can't just treat the employees in the same way, because if you do, you end up in the kind of situation John Holland found itself in, which is that they'd kind of just assumed, well, this behaviour is unacceptable. We won't tolerate it, without actually thinking, well, hang on, the employee is subject to a particular condition. We need to have a different approach for this employee. So I just thought it's relevant to bring the case up now, and to kind of, because it does have particular relevance in the pre-termination phase as well, when you first come across these types of issues. The next matter we're moving to is termination. Few different things to consider. The first is, if you are dealing with a work-related injury, there is workers' compensation legislation that prevents termination within the first 6 months that someone has become unfit. And that's just a blanket thing you need to be conscious of. The next thing is that unless the employee can't perform the inherent requirements of the role, sorry, I might rephrase that. You should not be dismissing unless you can identify that the mental illness has resulted in the employee not being able to perform the inherent requirements of the role after you've made reasonable adjustments. So employees are protected by discrimination legislation. Ordinarily, if their condition affects their ability to work, you cannot treat them differently unless it's linked to this inherent requirements consideration, and that's something that you've heard Kate talk about previously. When we talk about the termination process, there really is if you like, a tripartite-based process, a kind of three-step process, where the first step is gathering the evidence. So this is before you put what we often call a show cause letter, or before you put allegations to an employee, you need to go out and get the medical evidence. It will be extremely rare for an employer to terminate an employee's employment on medical grounds if you do not have medical evidence that you've obtained, if you do not have a medical report that you've sourced in relation to the condition. And that medical report should have questions on it. It should be asking the relevant medical professional, what's the nature of the condition? What's the prognosis for the employee being able to return to work and being fit to perform the duties in the immediate future? If they can't return in the immediate future, when will they be able to return? If they can't return, are there reasonable adjustments that you think we can make to enable the employees to return? And all of those questions need to be put to the medical practitioners that are best placed to advise on this issue. And there's really two types of practitioners you can go to. One is an independent medical specialist. So if you're not comfortable with the evidence coming from the employee, you can go to an independent. You might have heard them called IMEs before, independent medical examination. But the other is sometimes the employee's own treating practitioner can provide you with the information. If an employee's been getting medical certificates for 6 months from a doctor telling you that they're too stressed to attend for work because of a particular condition, it may be that you can go to that doctor and say, look, you keep sending these certificates, can you please provide us with this information so we can properly form a view about these questions? And once you have that information, you've ticked the evidence box and you move to the show cause box. And what happens at that level is that you then really need to give the employee the opportunity to respond to your preliminary views about whether they can or can't perform the requirements of their role. You should be telling the employee, we've received this medical report, here it is attached, based on the information that we have reviewed, we formed a preliminary view that you can't perform the requirements of your role, but before we make any decision, we'd like you to respond to that view, and we'll consider your feedback and then make a decision. You then ultimately move to make a decision. If that decision is to terminate, you would communicate that to the employee, and that's the point at which the other considerations come in. That's the third step. You look at their employment history, their length of service, and things like that will factor into just how much opportunity you should give the employee to improve, to kind of get back on their feet, so to speak. If an employee is to bring an unfair dismissal claim, the Commission's going to be far more concerned about a dismissal with an employee with 20 years service than one with a couple of years service. And so they're the kind of factors you need to build in to your assessment about whether you can or can't make reasonable adjustments. Also, you need to be thinking at this point about notice requirements. You do have an obligation to terminate with notice. So are you going to enable the employee to work it out? Is there no point? Are you going to pay in lieu? In a lot of these circumstances, we see payment in lieu, but sometimes an employer will terminate with notice, and the employee might just sit at home during the notice period because they're unfit to come in anyway. I saw a question there. There's a question about whether this only applies to workers' comp situations. The answer to that is no. Whenever we're dealing with unfit employees, you really got parallel considerations. You've got the question about what do we need to do from a workers' comp perspective, but in any event, there are, as Kate mentioned, discrimination laws and unfair dismissal laws that overlay any consideration of a termination of an injured worker. And if you don't follow this termination process we outline, then you're either going to be hit with a discrimination claim, saying you've treated the employee adversely because of their mental disability or their mental illness, or alternatively an unfair dismissal claim. So that's really the termination process. That feeds into the next comments about risk. You see there a circular graph identifying the different types of risks. Workers' comp we've mentioned, unfair dismissal we've mentioned, disability discrimination we've mentioned. In relation to general protections provisions, many of you may have heard of the adverse action provisions of the Fair Work Act. These provisions generally prohibit employers treating employees differently for a whole range of reasons, including because of someone's mental or physical illness or injury. What applies to these laws is what's called a reverse onus that is, once an employer has taken an action like dismissal, the commission or a court will assume that the reason the action was taken was one which is prohibited by the Act. That is, they assume that the reason you took the action is because someone had a mental illness, and it's then for the employer to prove that their reasons were lawful ones. And in order to do that, to show that you've acted lawfully, you're really going to need to fall within this inherent requirements exemption that Kate's talked about already. So that's another area. Breach of contract, that applies less so. I mean, it's more important with the contractual considerations that you're aware of what the contractual provisions are, you're ensuring that you're complying with whatever procedural requirements, notice requirements, etc. are outlined in the contract. So that's really kind of the main risk areas you need to be conscious of. In terms of privacy laws, the reality is that privacy laws will not, sorry, I'll rephrase that a bit better. The Privacy Act does not apply to acts engaged in by an employer that relate to employee records and where those acts are directly related to the employment. So if we are talking about records in relation to an employee that directly relate to the employment, then records in relation to an employee that directly relate to the employment, then ordinarily, provided you don't disclose these materials for purposes unrelated to the employment, then the privacy laws have limited application. But if you start to use that information for other purposes, that's when you end up in a spot of difficulty, really, and exposing yourself to liability. Just going to the risks a bit further, you'll see there the slide about workers' compensation. You just need to be conscious that if you terminate within the first 6 months, there's a liability. And in fact, in New South Wales, if you terminate any time within the first 2 years of a workers' comp claim, if the employee subsequently becomes healthy again and is able to return to work, there is a process in the Act to seek re-employment within the first 2 years. Moving on, you'll see references to unfair dismissal and disability discrimination protections. Again, it's all about inherent requirements as well as ensuring procedural fairness. And the point about procedural fairness is you really need to go through that process that we outlined above earlier, that 3-step process. That's about it really in relation to the risks. I was going to hand over, I was going to deal firstly with the Salazar and John Holland case, but in my eagerness, I jumped in. I couldn't help too early, so there's probably not a great deal more to cover on that. You'll see a summary of the relevant case there, the finding that the dismissal was unfair because the employer really relied upon some behaviours without reference to the medical condition of the employee. You'll see their comments, it is neither sound nor defensible to rely upon conduct of an employee with an obvious mental health problem in drawing a conclusion that the conduct of the employee amounts to serious misconduct. We do need to treat the case with a little bit of caution because it was overturned based on a failure to afford procedural fairness and then ultimately settled. But it's nonetheless instructive of the types of concerns that Fair Work Commission members may identify if the process isn't properly carried out. So at this point, I'm going to hand over to Kate because she's going to talk to you about Grant.
Thanks, Lewis. And there is a question I note there as well, but we might just deal with that one once I've dealt quickly with Grant. So Grant is a famous case really in this area. It's a solicitor who's working for the Office of Public Prosecutions in Victoria. He initially had a physical injury, so he broke his leg, and after that his work attendance was fairly sporadic for a period of time. He had some associated problems with his injury, such as DVT. And then even after his treatment finished, so even after he'd recovered from his physical injury, his absences from work continued. Being a solicitor, being in that high pressure environment, this started causing problems with his case management and preparation. People started to notice. In February 2012, his employer conducted an initial performance management discussion with him, and at that time he provided a medical certificate saying he was unfit to work at all for a short period of time, and referenced that he was suffering from a depressive sort of illness. Later that month, in February 2012, he was directed to take leave without pay and to provide a detailed medical report on the condition that he was suffering and the impact that it was having on his duties. And that's where we start to talk about what we can see in the slide there, was that he had a long-term anxiety condition rather, that was complicated by self-medication with alcohol, and that this had depressive elements to it as well. That report also noted, however, that the employee was responding to treatment at that time. But by March 2014, the employer saw fit to undertake an investigation into alleged misconduct engaged in by the employee, and included in those allegations was that he had disobeyed lawful directions from his employer. The result was that the allegations about his misconduct were substantiated, with disciplinary action being the result in accordance with the public prosecutor's policy, and ultimately his employment was terminated. So the things that he'd been doing were not turning up to court, not providing detailed briefs to barristers, and things which were really, really key, important things at the core of his duties. So at first instance, the employee claimed that the employer had taken adverse action against him by dismissing him due to his illness, and he also argued secondarily that the misconduct allegations were false. At first instance, which was a single judge in the federal court, it was found that the employee was sacked because he had misconducted himself because of his illness. However, the judge didn't accept that the decision maker, who was the employee's boss, had a state of mind at the time of his decision to terminate which didn't have his ill health as one of the factors which had bearing on his decision to terminate. And said, I think it was quite clear that it was part of the reason he was dismissed. So I think the important thing to note here is you can't terminate on the basis of mental illness. So if you're contemplating having that being a discussion, having a discussion with an employee who has a mental illness, who's had some subsequent conduct or performance issues, you really need to be ensuring that the reason you're making that decision and the communication you have with the employee is that the reason that the termination or the disciplinary action is being engaged with is because of the poor performance or the employee's behavioural conduct. So at first instance, unfortunately in this situation for the state of Victoria, it was found that adverse action had been taken against the employee, and he was ordered roughly in the order of about $93,000 in compensation. So you can see the risk with these kinds of cases as well, differentiating from an unfair dismissal, is the potential for monetary awards to the employee or to the applicant are greater than what we would normally expect to see in the unfair dismissal jurisdiction. The state of Victoria did appeal the decision, and this came about after the High Court decision, the BHP decision, which some of you may be aware of. That was the one where BHP appealed all the way to the High Court against a finding that they had taken adverse action against an employee who had engaged in industrial action. Here, it was found that the full federal court found that this solicitor for public prosecutions had given clear evidence that he made the decision solely on the basis of the employee's misconduct, not because of anything else that was relevant to the situation, such as his mental illness. There was no contradictory evidence given by the solicitor for public prosecutions, and he had given honest evidence. So while he had known of the mental illness, the medical evidence didn't expressly or impliedly link the misconduct and the illness. Therefore, it wasn't open to the trial judge in that first instance to include that the two were inextricably linked and that the decision maker couldn't have separated the two when he was making the decision whether or not he should terminate employment. So I think, and ultimately, the decision was overturned in this instance. So it was found there was no adverse action. What we need to take away from that is, and this is probably something which is becoming apparent during our discussion, is that just because there's a clear relationship, or a close relationship rather, between the adverse action, which is the termination or the decision to engage in some kind of disciplinary action, and the prohibited reason, which is the employee's mental illness, it doesn't mean that the two can't be separated. So it doesn't mean that just because you terminate someone who has a mental illness, it doesn't mean that that necessarily has to be that being the reason. If you're able to give clear evidence that your decision was entirely centred around the performance management or the performance concerns you had with the employee, or the conduct, as it was in this particular case, that was what was the concern, then you should, it will be easier for you than perhaps we otherwise would have thought it was before these cases, to demonstrate to a court or tribunal that you didn't make the decision for a prohibited reason, which goes back to what Lewis was saying before about there being a reverse onus proof in these situations, which is essentially the employer has to prove that they didn't make the decision for the prohibited reason.
I've just noticed one question that's come up regarding what happens if a prospective employee discloses they've suffered from anxiety or depression at the interview stage. Is that reasonable not to hire them? It's again a kind of a little bit of a Pandora's box there. The reality is that if someone discloses a mental illness, that should not be a reason, and law, as far as the law is based, that should not be a reason that factors against hiring the person, unless it's the case that you can't be satisfied that they'll be able to perform the inherent requirements of their employment position because of that illness. Now, the problem you have at the introductory stage is you're not going to go off, in most cases, and ask them to get medically assessed and have this whole kind of show cause process where they tell you whether they can or can't perform the job. That's probably not going to be practical for employers, which puts you in a difficult position, because it means you're not going to be moving with the same level of evidence that you would at the termination point. So you really need to consider quite substantially, if you're advised of a particular concern, you need to really think, is this materially going to impair them performing the inherent requirements? If it is, then that's a basis not to move, but you need to be conscious that you're going to want it to be clear cut, because you're probably not going to have the clear medical evidence you do have at the termination point, unless it is that you're actually willing, if you really think they're a good candidate, but you just want to kind of cover off this last issue, you could actually say to them, look, we want you for the job, but we just need to be satisfied you can perform the role. We will need you to have you medically assessed, and that's a legitimate course of action to take. Employers don't often do it at the beginning of a process, but it can be done. If you do hire them, does that cause issues regarding performance management later on? Well, it can, if you're fully aware of the issues involved. But again, I say, if the inherent requirements of the role are quite clear, that should still enable you to proceed down a performance management and termination path if at some point they become unable to perform those inherent requirements. Just to wrap up, one thing I should say, we have seen a number of comments. I think that it does appear that some of the early advertising for this webinar that's been put out hasn't matched the topic that we presented today. So I do apologise if some of the advertising hasn't aligned with the topic of the presentation. I do hope for those of you that stuck around, it's still been valuable and helpful. I think that's pretty much it. Oh no, we've got one more question that Kate is chomping at the bit to answer for us. So I'm going to throw her in it. And I think it's a bit broader than mental illness, but we've got a little bit of time.
So I think it was a question about how dealing with employees who are frequently absent from work on personal leave, who do have a mental illness and thus not performing their job. And that's where we start having to implement the process of obtaining medical evidence from the employee about the nature of their condition, about their prospects for improving. Obviously, if an employee has exhausted their personal leave entitlement, there might be some reasons to ask some questions there if they're requesting personal leave without pay. We also have to be conscious of not taking any adverse action against an employee who has had a temporary absence for an illness or injury, which is one of the adverse action provisions. But I suppose coming back to what we can actually do, if we've been going on for a relatively long period of time, still a problem, still no improvement, we really need to be there for a relatively long period of time, still a problem, still no improvement. We really need to be then looking at the employee and saying, okay, I understand there's a problem here, looking at whether we can make any reasonable adjustments. But the first thing you might want to be looking at there is we need to really understand the nature of your illness, how the symptoms are manifesting themselves and affecting your ability to come to work. Can we put reasonable adjustments in place once we've got that medical evidence to reflect upon? If there's nothing we can really do and we can't continue to support the employee in the employment, they can't perform the inherent requirements of the role, then we might be proceeding down the performance management or ultimately termination of employment path. So it's a really tricky question to be grappling with, but I think the important thing here is to be ensuring that we're actually communicating with the employee, asking them to provide that medical evidence or asking their permission to obtain that medical evidence ourselves, and then making educated decisions rather than trying to work out what's going on without actually having those
And the other thing I'd just add, when you do have absenteeism like that, also don't discount the other practical means of dealing with something like that. If you have an employee that's being absent regularly, one of the first things to do is to put in place directions to report within a prompt period of time the fact that they're going to be absent from work, to indicate to the employee that they need to be providing medical certificates within a particular period of time, might be 24 hours from when they've been absent, giving them a point of contact they must contact, might be 24 hours from when they've been absent, giving them a point of contact they must contact the moment they become aware that they're not going to be well. And if you put in place some quite strict structure about reporting and what they're meant to do when they become ill, particularly in relation to furnishing medical certificates and things like that, it can really start to nip in the bud, if you like, the actual poor practices. And we often see employers going one of two ways: either A, they'll improve attendance patterns, or B, they'll start to breach your directions, and then you end up in a disciplinary process anyway. I think we're kind of running out of time, so
Yeah, sure. Thanks, Lewis, and thanks, Kate, for today's session. You've kind of answered a few questions as you've gone along there. So what I can do for everyone, I've put on the screen now Lewis and Kate's details. So if they haven't managed to get to your question, you're welcome to email them through either of the guys there, and they'll get back to you as soon as they can. Thanks for Lewis for sending out the apologies there. Obviously, some of the participants today wanted us to also cover bullying and harassment there. What I'll do is when I send out the recording of the slides, we also did a bullying and harassment webinar back in July last year. So I'll send out the recording for that session, and we will be scheduling in another